Hello once again, and welcome back to the Global Students Introduction to the Law of the United States. I am Professor Pedro A. Malavet, and today I will be discussing the constitutional powers of the United States. The United States Constitution provides for three governmental powers in its first three articles. Article 1, the legislative power, Article 2, the executive power, and Article 3, the judicial power of the United States. In graphic form, you see it here. The Constitution sets up the basic structure of the American government: a legislature, which passes statutes or laws; an executive, a chief executive, the President of the United States, who heads the agencies, the cabinet, and it is the agencies that issue regulations, which have the force of law to some extent, and the President himself can issue executive orders. The judiciary, of course, in a common law system like ours, issues decisions which become case law. Article 1 designates the legislative power to be held by a Congress. And this is, of course, the seat of the United States Congress, the United States Capitol in Washington, D.C. Congress has enumerated powers. It is so said in the Constitution. And Article 1 starts by vesting that legislative power in the United States Congress, and Section 8 articulates the enumerated powers given to it. This was a compromise at the Constitutional Convention, and the basic principle is that anything that might be disruptive of the harmony of the United States as a single nation had to be reserved for the legislative power of our national government. And the enumerated powers are these: the power to issue money, to establish a postal system, to create the federal courts, to raise an army and a navy, to provide for the national defense, to declare war, to collect taxes and spend money for the general welfare, and to regulate interstate commerce. These are the most important ones. The legislature itself is a bicameral legislature. It is composed by a House of Representatives, which includes proportional representation, meaning that it is based upon the population of each state. The representatives, or members of Congress, are re-elected every 2 years, which means that they have to be very close, to their districts and to the people whom they represent. The Senate has equal representation from each state, 2 senators from each state, and they serve 6-year terms. Both houses have to agree on any piece of legislation before it may become law. The power to raise funds. Congress literally has the American national power of the purse. It includes the federal power to tax and spend, and this was overwhelmingly supported by our founding fathers. It was considered absolutely essential to having a national government, that national government should be able to raise money. Revenue bills, however, must originate in the House, and this is to ensure a concept that many people have heard before: no taxation without representation, because that was, after all, one of the fundamental complaints of the colonists at the time of the Revolutionary War. This also limits the other 2 branches of government. The fact that the legislative branch is required to authorize budgets, to authorize spending, is a limitation on what the executive and the judiciary can do. The Congress also has the power of impeachment, meaning that they may remove any officer of the executive or judicial branch by a vote. This is another kind of check that allows the legislative to limit what it might consider overreaching, an excess in power by the other branches. And it specifically applies to federal judges and to the President of the United States. The House and Senate today are composed of 100 senators, 435 members of the House of Representatives, one per district. There is a minimum of one representative per state, given that there are states that have less than 640,000 residents, which is the average number of people represented by a single representative. There are also 6 territorial representatives who represent the territorial possessions of the United States. In addition to the 50 states, the United States has legal authority under the Constitution over 6 territorial possessions, and those territorial possessions are given one non-voting representative in the House. Congressional committees. The work of legislating in this country has become so complex that the Congress requires committees to perform the studies, to perform the drafting work that will eventually be presented to the entire House. There are 298 total committees. They are divided between so-called standing committees, which are basically permanent, special or select committees, and subcommittees. There are also, importantly, investigative committees. The investigative authority of the legislature is an important power. And of course, investigations are generally used to determine the need for legislation, and were not conceived in the Constitution. They're not mentioned in the Constitution, but it was thought that it was absolutely necessary for the Congress to have investigative authority in order to exercise its legislative power. The Supreme Court approved of this and has, in fact, upheld the Congress's right to investigate. The Congress's power to investigate includes subpoena power, which is generally given to the judiciary in the United States. Subpoena power allows them to call people to come testify before the Congress, and subpoenas also allow the Congress to obtain information, documents, tangible things. And the subpoena power of the legislature is enforceable through contempt. Contempt is a typical authority that is exercised by courts to punish people who disobey a judicial order, and Congress has been given that authority attached to its investigative power and attached to its subpoena power. Congressional staff. Congressmen and women do not work alone. They have a fairly large staff. It is headed by the General Accounting Office, which provides them with assistance in their oversight role, meaning that the legislative has the authority to exercise oversight over how the money that they authorize is actually spent, for example. There are committees that have almost 3,000 congressional staff members who just work on committees, and also the investigative committees in particular will hire investigative aides, attorneys, and other types of investigators in particular. And there are the staff members who work for each congressman or woman, over 11,000 of them, averaging 38 per congressman and senator, and 18 for each House member. The executive power of the United States is exercised by the President of the United States, and the President's residence and office is, of course, the White House at 1600 Pennsylvania Avenue in Washington, D.C. Article 2 of the Constitution of the United States vests the executive power of the United States in the President of the United States of America. The President has the duty, the obligation to take care that the laws are faithfully executed, including, of course, the Constitution itself and the laws passed by the United States Congress. The President also is allowed to appoint executive officials and other officials, including, importantly, Article 3 judges, with the advice and consent of the Senate. Executive departments are created by statute. They were not originally provided for, but they have been created by statute as the nation's legal business and executive business have increased and have required more workers to perform it. An important presidential power is the power of the veto. The president has the power to strike down any piece of legislation before it becomes law. It is important to understand that the president has to reject the entire law. The president is not allowed to pick and choose a part of a legislation that he does not like. Say the budget. He doesn't want money spent for a particular purpose. He cannot reject just that expenditure. He must reject the entire budget. A veto may be reversed by Congress by a 2/3 vote of the House in which the bill originated. Article 1 provides that. Interesting, because the veto override was not included together with the allowance of that authority in Article 2. It is actually included within the powers of the legislature. This is the relationship between the Congress and the president, one of those checks and balances that we will discuss later on. Major presidential powers include the power over foreign affairs. In this area, the president is given a great deal, not only of authority, but also of discretion, how to deal with international problems and with governments other than that of the United States. In the Constitution, this is articulated as the power to receive ambassadors and other public ministers, and basically to choose which governments the United States chooses to recognize and with whom we choose to do business, with whom we choose to have a relationship outside of the United States. Another critical power of the president is, of course, his power as commander-in-chief. The president is the literal head of the armed forces of the United States, meaning that he is a civilian who has absolute authority over our military. The president implements legislative programs. This is mandated by the Constitution, as I told you earlier, that he has a duty to take care that the laws are faithfully executed. The president, therefore, is required to actually implement, to carry out the legislation that is passed by the United States Congress. However, he has an inherent authority, an inherent discretion, meaning he has to implement the law. He doesn't have to do it particularly enthusiastically or aggressively if he does not believe in it. The president has a cabinet, and this is President Obama's cabinet, and in the picture below you see the president leading a cabinet meeting at the White House. The cabinet is composed by the heads of all executive departments of the dependent agencies of the United States. They are not ministers, as is commonly used term around the world. They are called the executive officials. They are called department heads and generally called secretaries. They are not called ministers. These secretaries are appointed by the President of the United States, but he is required to obtain the advice and consent of the Senate in order to have them be able to take on their job. The development of federal agencies to assist the President in carrying out executive power is, as I mentioned earlier, not expressly included in the Constitution, but it is today an absolutely essential assistance for the President in carrying out the executive power of the United States. The very first executive agency was the Interstate Commerce Commission, which was created by congressional enactment. And in fact, there's a great deal of cooperation between the President and the Congress, because the Congress has to often issue enabling legislation to create a department such as the Interstate Commerce Commission and the Department of Commerce, and also the legislature has to give those departments money to carry out their work. The development of federal agencies has been a somewhat slow process, and most of its development is really during the 20th century, and particularly beginning in the 1930s with the New Deal. The Great Depression of the 1930s put the United States in a deep economic crisis, and President Franklin D. Roosevelt asked for legislation to create a variety of administrative agencies to help the nation's citizens come out of this economic crisis. And this represented a major growth in the executive power of the United States. In addition, even more recently, we have what we would describe as a modern regulatory state, meaning that agencies are regulating different areas of activity, usually carrying out congressionally delegated powers. And at the state level, there has been a similar growth in executive authority being exercised through agency authority, which is then exercised through regulations. Agency rulemaking, regulations, are legal rules which are issued by the agencies and which are enforced by these administrative agencies. They are generally based upon delegated powers given to them by Congress, given to them expressly, generally, by legislation. So the legislation cannot possibly be specific enough. So the experts within each agency issue specific regulations based upon their expertise in a particular field. That is the way executive authority is exercised, but keeping in mind that it is delegated to them by not only the Constitution, but then expressly by legislation from Congress. There are two types of agencies: the executive agencies, which are directly controlled by the president, and independent agencies. The executive agencies are those that are headed by the secretaries who are members of the cabinet, and they are completely subject to presidential authority. A secretary serves at the discretion of the president. The independent agencies, however, are not formally subject to the supervision of a cabinet member, meaning that they are not subject to absolute presidential authority. The independent agencies, instead of being headed by a secretary, by a cabinet officer, are headed by a collegial body, by some kind of directorship structure. The president generally appoints the members of these collegial bodies, but they are, of course, subject to advice and consent of the Senate before their appointment. And then, importantly, they're appointed to a term of years. And that is done purposely to keep them independent from the political power of both the president and the legislative. Examples of independent agencies are the Securities and Exchange Commission, which regulates financial securities, Federal Communications Commission, which licenses television and radio stations in the United States, the Federal Reserve Board, which controls our monetary policy, something that has lately been quite important, and the Federal Trade Commission, which regulates certain trade practices in commerce. So far, I have been discussing the two political powers of the United States government, meaning the elected officials who operate in the United States government, the legislative branch and the executive branch. Now we get to the unelected branch of government, the judiciary. And the highest court in the United States is, of course, the Supreme Court of the United States, which is housed in the Supreme Court building across the street from the Congress in the nation's capital, Washington, D.C. Article 3 of the Constitution of the United States states that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. This is a compromise because the existence of federal courts was a matter of dispute at the Constitutional Convention, and in particular, whether or not there should be lower federal courts. They all agreed that there ought to be a Supreme Court, as we see in the Constitution, but there was disagreement. The Federalists wanted lower federal courts to carry out the nation's legal business, but the Anti-Federalists were concerned that such courts would unduly interfere with the authority of the several states. So therefore, they left it to the United States Congress to create the lower federal courts, and this has to be done by statute. The jurisdiction of the federal courts of the United States is limited. By comparison, state courts are courts of general jurisdiction, but the federal courts are courts of limited jurisdiction. They are limited to the authority given to them expressly in Article 3 of the Constitution. And that primarily means that they are limited to controversies between citizens of different states, or what the Constitution labels aliens, people from outside of the United States, people who are not citizens of the United States, and to cases arising under the federal laws and the Constitution itself. Congress has to enable this authority. In other words, Article 3 designates the judicial power of the United States in its maximum authority, but that authority requires enabling legislation from the United States Congress. And for the most part, Congress has not fully enabled the authority of the federal courts to take on cases to the full extent permitted by the Constitution. The statutes that provide for the exercise of jurisdiction in the lower federal courts primarily deal with so-called diversity jurisdiction, meaning the controversies between citizens of different states, and that includes also alienage jurisdiction, that jurisdiction based upon a suit involving a United States citizen and a citizen of another country. And then what we label federal question jurisdiction, which are questions arising under the Constitution or the laws of the United States. It's interesting to note that diversity jurisdiction was enabled by the Congress in 1789, very early in the history of the Republic, but federal question jurisdiction was not given to the lower federal courts until 1875 in the post-Civil War period. And I will explore this in another part of the course in a series on the judiciary and the judicial structure of the United States. Article 3 judges. The members of the federal judiciary who belong to so-called Article 3 courts are called Article 3 judges because Article 3, Section 1 of the Constitution itself designates them as federal officials. And it states that federal judges shall hold their offices during good behavior, meaning that they're subject only to impeachment. That is why we generally refer to a federal judge as a lifetime appointee. They can only leave office upon retirement or death or upon impeachment. That's the only involuntary way for a federal judge to leave his or her position. In addition, the Constitution protects judges by stating that their compensation shall not be diminished during their continuance in office. This is an example of checks and balances. Remember that Congress has the authority to spend money. So therefore, if they don't like a judge, they could conceivably say, we're not going to pay you a salary. Well, the Constitution protects an appointed judge from that with this provision. The appointment of judges themselves is another compromise from the convention, and it states that the president has the power to nominate a federal judge, an Article 3 judge, but that the advice and consent of the Senate is required for their appointment. And this is called the confirmation process, and it applies to all federal judges, including the justices of the Supreme Court of the United States. The basic U.S. judicial structure as designated in the uscourts.gov website, which is the United States Article 3 Courts website. You see the Supreme Court. Now there are, as provided by statute, appellate courts, which are the circuit courts of the United States, and there are trial-level courts, the United States district courts, within each one of the states. There are also certain specialized tribunals, the bankruptcy courts, the Court of International Trade, the Court of Federal Claims. And then there are other kinds of courts which are not considered Article 3 courts, the military courts, the courts of veterans' appeals, the tax courts, and administrative agency boards. Those are not within the Article 3 judicial power, unlike the first three categories. This, of course, is a map of the United States, but it is a judicial map of the United States. And here you see the geographic coverage of each one of the circuits. The numbers within the circles are the circuits of the United States. The First Circuit, we happen to be in the 11th Circuit down here in Florida. There are also district courts in the territories. You see the territorial possessions of the United States here. Down here you see where I was born, Puerto Rico, which has a district court. Next to it, the United States Virgin Islands, another one of the territorial possessions. Over here, you have the Marianas, and here you have Guam, and these are 4 of the territorial possessions of the United States, and because they have an Article 3 court, they are included within this map of the United States courts. To conclude this overview of the first 3 articles of the Constitution creates the basic structure of the American government. That is what those 3 articles about which I have been speaking do. But they purposely created possible areas of questions and areas of possible conflict. It was, after all, a new nation that they were bringing forth in 1789. And it's therefore, they were not prepared to answer all of the questions that might come up. And therefore, it would initially be up to the courts primarily to resolve many of these open questions to the extent that the political process could not resolve them.